Hi everybody, I'm Mel Forbes, the Managing Director of APSCO Outsource, and I'm absolutely delighted to be joined today by Adam Waldridge, Director at Volt, also on the APSCO co-chair for the IT sector, and Dawn Ford, Legal Counsel for Volt. And we're going to discuss compliance benchmarks for HR and procurement professionals, and we'll dive into risk, different worker types, partnering with MSP RPO providers, and also how to ensure compliance in the ever-changing environment that we find ourselves operating in. Risk, once considered a very dull topic, has such an impact on commercial decisions, and how as an organisation risk, cost, return on investment are so intrinsically linked. So we can't possibly cover everything in 30 or so minutes, but what we do want to do is give you enough of a view to support and help you wherever possible. So Dawn, we often hear the term first generation, second generation when discussing outsourcing. What actually is the difference?
It depends on how long you've been doing whatever you're buying. So whether you're buying MSP, RPO or statement of work, are you a newcomer to it? And if you're a newcomer, you're first generation. And if you're second or third, you've bought those services in the past, you've moved on to a new provider, and hopefully you've learned something in the process. So knowledge and expectations really are the key differences. The first generation don't know what they don't know. So they generally don't know what workers they've got. They don't know how to optimize things. They sometimes want to fly before they've learned to walk. They want to change things really quickly and don't necessarily bring their supplier base on the journey with them. They don't know what the risks are. They don't know how to prevent them. And they often don't know what they're buying. When you get into the second and third generation, you still get a real variety there, because obviously it depends on the experience they've had as a first generation client as to what they learnt in that process. But generally speaking, they will have a much better idea of what type of workers they have and where they exist. Their processes will be better optimized, but there'll still be progress that they can make on that. But much greater spend visibility, as long as they're mandating their processes internally, which they might not be. They'll have improved their compliance, but they probably won't be auditing enough. So they might have a great contract, but they won't actually be checking on a day-to-day basis what's going on. And they won't necessarily be benchmarking. So they know what they've good, but they don't know what good looks like outside of their organisation.
So what you're saying there, I guess, is that risk changes depending on whether you're first generation, second generation, third generation. The risk actually evolves. Is that what you mean?
Absolutely, absolutely. And the foundation of managing risk always starts with knowing what your risk is. You can't manage it until you know what it is. And so first generation clients invariably have more risk because they know less about their worker population or the scale of their outsourced work. And until you can kind of get your arms around that and know what you're dealing with, you can't control the risk of that. So if you don't know how many or what types of worker you've got, you can't control spend. But also you probably can't complete the RFP properly in the first place. You know, it's a bit like all of us going out to buy clothes after lockdown, isn't it? We go out buying our previous size, and actually we're now a new size. You know, you need to be an educated buyer when you go out for these kind of things. So I think that's a sort of common mistake in first generation. And obviously the way risk changes in compliance is very variable as well. So first generation clients are probably going to have some tax or social security irregularities, especially if they're in the MSP RPO buying space. They'll probably have some workers without right to work. They might have some temporary workers who in fact become their permanent employees and they didn't know it, because obviously in some jurisdictions, although that's not the case in the UK, there are very strict cut-offs as to when you become a permanent employee of the end client. So that might have happened without you even knowing as a first generation client. So I think your generic compliance risks change over time, but also your financial compliance risks change over time, which can be anything from rogue spend, or you don't have full visibility over what you're spending, or you've got hiring managers going off and buying from suppliers that you haven't necessarily checked out and added to your preferred supplier list, your MSP, RPO, outsourcing, whatever model you're using. But also you might not be paying the right cost for those things if you haven't got a fully optimized process. And then the final cost piece is, of course, the one that comes to bite you down the line, which is if you don't get things like your social security right now, it's not costing you anything in today, but in 5 years' time, when HMRC finally gets around to chasing up on those things and comes after you, then that's the problem you're storing up for the future. So the financial risk can be both in the present day and in the future. And obviously the executive boards of your businesses are going to be wanting to look at all of those things.
And often, particularly with first generation, I've heard the term a lot, worker audit. And also, that in itself can strengthen the RFP process. So to that point, Adam, can I just bring you in there? What do we actually mean by worker audit, and how can it strengthen that process?
Yeah, I think this really comes down to, Mel, to really understanding who your contractors are, the roles they perform, where they're physically based, and how they're actually contractually engaged as well. So PAYE limited, if in the UK, is that inside, outside of IR35? Could they be a sole trader or even statement of work? So there's a number of diverse different engagements these contractors may be working on. And as Dawn said, because the foundation of managing risk starts with knowing what your risk is, until you know what your worker population looks like, you can't really assess that. So the RFP process will be, I think, fundamentally strengthened, as you'll be able to get essentially a better commercial deal, because most RFPs I've seen have really sort of wildly inaccurate estimates of spend. And of course, providers are going to price based on what spend they realistically think they're going to get from the programme. So being accurate is really the best way to get the good price in an RFP. I've been speaking with a large FMCG client recently. They hadn't done a worker audit and they're really unsure about their contract numbers, spend. These contractors were dispersed across Europe in a number of different countries under a number of different tax structures, which isn't all that unusual. And a good provider can certainly help you put your arms around that and understand what that looks like. But the client said to me at the end, well, what's my pricing look like? And I couldn't actually give them pricing because I didn't know to what degree the worker population may or may not require restructuring. If you are going to go down that restructuring route as well, an RFP stage, it's really key that you get the business bought into that as well. I've had situations where, we've had to move a large number of contractors from sole trader to limited. We briefed the hiring managers in advance on webinars. We had their support. However, without that, we never would have had a coordinated approach to the contractors, and the goals of the RFP would never have been realised. At the other end of the spectrum, perhaps spend is wildly inflated, as I've seen before. And this causes problems with the effectiveness of the supply chain because, again, you may have suppliers that have agreed to certain commercial agreements in good faith, but then when they realise that, the programme doesn't perhaps look like that, will the RFP stage ever get past the RFP stage to the programme stage? And if it does get to the programme stage, are you going to have an engaged group of suppliers that are going to ensure the success of the programme? So getting that worker audit right at the beginning was really key to ensuring a successful RFP.
And you covered there quite, there's so many different worker engagements you can come across when you're doing that audit. And I assume then that the risks associated with different engagements, and you just touched on a couple there, Adam. Do you want to expand that part of it? What some of those risks are associated with different ways of engaging workers?
Absolutely, and we've only got so much time today, right? But ultimately, a good partner is going to be proactive about giving you line of sight on what these risks are, things that are coming down the road in the future. So they may not be dangers today, but perhaps they're concerns tomorrow. Again, if we look in the UK, good example of that would be IR35. To what degree did your supplier give you a heads up on the impact of this legislation to prevent a last-minute dash to comply with new regulations? Because of that, and also for other reasons too, a lot of organisations have pushed contractors down essentially an umbrella adoption method. So umbrella usage has become really popular this year with worker assignments, which creates a big question around the umbrellas that you use. How do you know they're actually compliant? How do you know they're doing what they're supposed to do and that they're not leaving you open to any financial, reputational risk should they not be? There are some other issues to consider as well with how contracts are paid. So typically, perhaps if you have a lot of PAYE workers on assignment with you, particularly those that may be in blue collar or manufacturing type positions, how do you know, that you have prevented the risk from your supply chain from modern slavery perspective, which maybe we'll speak about a little bit later on. And if you're amending how workers engage with you, because of any number of reasons, this can lead to contractor turnover as well. So if the messaging and process around why a change is happening isn't sufficiently communicated in advance and managed again between the supplier and the hiring manager community, this can cause a number of problems for the client in terms of contractor turnover. And there was a very documented walkout of contractors from TfL a few years ago around the change in limited company structures, which had a huge knock-on effect to the timescales for the delivery of a number of IT projects there at the time. Cost risk is another. So I've seen that happen a lot in the banking sector, for example, especially where there's blanket decisions to perhaps move people to certain tax structures and away from limiteds. But this concept applies more broadly. So if you're engaging contractors in structures that may be not as tax efficient as others, you run the risk, certainly, especially of certain key contractors, but they may come back to you to request or worst case demand an increase in their pay rate to compensate for this. And the complexities around that effectively mean that you may have one pay rate for one structure and another pay rate for another, which is certainly far from desirable. So, I mean, trying to get everything perfect from day one may be unrealistic. And if it's such a departure from what existed before, it may be completely unrealistic. So companies that do demand, I suppose, this utopian ecosystem to work with from day one, especially the first generation supplier, should be mindful that to move the dial so much could also come with a huge commercial price as well. So there's certainly a balance to be had between, I suppose, a level of compliance that you're comfortable with, but also sort of the commercial impact of that and a price that you're happy to work with as well. So there's that real balancing act of compliance versus the right price.
But also when it comes to worker engagement, the different types, there's also that piece around operational need. So you talk then to a project that has to be delivered, but the engagement of the worker might be at a higher operational risk. But the need, does it outweigh the risk? So is it operational need versus risk? And in that scenario, Dawn, who wins? With your legal hat on, I think you might say risk.
I think actually it very much depends on the client and what level of senior stakeholder engagement you've got. Because if you're talking with someone on the executive board, the organisational risk is going to be on their agenda because they're the person who's going to be wheeled out in front of the cameras if they've got some kind of PR disaster going on. But at the same time, if you're talking to the hiring manager who has a project that they are targeted on to finish, well, it's all about the operational need. So actually, I think the key to this is communication with the client and having a really good understanding of what level of risk they are prepared to accept and who in the business has sign off of what. So I think it's crucial that you set out in your contracts and make sure it happens. That's the other point. Who needs to be involved within what kind of decisions within the business to make sure that whoever is responsible for risk within the client has a voice in that process, and you have a solution which works for both the client and you as a provider.
Yeah, that's fair enough. I think as well, and that a lot of people are saying that's a symptom of IR35 this year, but we've seen a steep increase in statement of work without a doubt. And I'm told that there's more risk associated with statement of work. Could you enlighten us a little bit more about that, as that's been obviously on the rise?
Sure. I think there's not necessarily more risk, there's different risk. So when you're providing a temp worker, you're worried about right to work, you're worried about tax, you're worried about social security, and you need to be worried about those things. You need to have those on your radar. Whereas when you move into statement of work, as a client, you have to dedicate a lot more time up front. You have to think about what the deliverables are that you want. So it's not, oh, I need someone to start on Monday. Here's a 2-line job description, off you go. That kind of the sort of historic recruitment perspective is totally different in statement of work. You really, as a client, have to spec out what your business needs up front so that you have a contract, which means you're buying the right things, which has deliverables which are matched to whatever your internal project timelines are. So they're the kind of practical challenges. But I think that the challenge which a lot of suppliers face, especially if they deliver both, they deliver time materials and statement of work business, is making that ideological jump between the two is quite difficult, because in time materials, you'd very commonly have a supplier say, well, I don't have any control over the worker, so I'm not accepting any liability for the work that worker does. Whereas in statement of work, you are contracted to provide the work. So of course you're going to have to take responsibility for that, because you are contracting to provide some piece of IT software or a certain number of manufacturing widgets, but whatever it is you're supplying, you have a duty to supply that. So the indemnities, liabilities, warranties, insurances are completely different because you are having to accept all of those responsibilities for the work. And that's not necessarily a problem because you also have greater control. The whole reason that a temp supplier will say, I'm not taking responsibility for this, is because as soon as the worker goes on site at the client, they've got no visibility of that, they've got no control. And so they reasonably say, you can't hold me responsible for that. But in the statement of work piece, as a supplier, you are totally in control of providing that work. And you will be speaking to your consultants, your employees, whatever models you as a supplier use on a day-to-day basis to assess how the project's going, what the potential problems are there any time issues that you need to be discussing with the client, is there any scope creep that you need to be discussing? So I don't think it's more risky, I just think they're different beasts. But I think one of the challenges we saw with IR35 was a lot of clients going, statement of work is our saviour, we will change all of our contracts to statement of work, which for some clients was possible. It's just that they didn't think it through. And I mean, I'm sure many of our clients that are listening to this will have had the same situation where they've, had a hiring manager that sent out a schedule for a worker on Friday, and on Monday they tried to send it out with just the name deleted and the title changed to schedule of works or statement of work, and thinking that, job done, they've done everything. And I saw that terrifyingly often over the last year in discussions with clients. So I think it's a brilliant solution. It's a great solution for many clients, but you need to go into it on an educated basis. It's totally different from buying worker time, and so you need to respect its differences and treat it accordingly. But I don't think it's inherently more risky, because as a supplier you get more information up front, so you can measure those risks, balance those risks and insure for them. It's just about making sure you understand the process fully before you get started. And it's, as ever, ignorance is what causes the problem, and I think that's the case for everything we're going to discuss today. It's when you miss something because you don't understand what the risk is, that's when the problem comes along down the line.
Yes, that is really, really helpful. I do want to touch on right to work, and the reason being is at APSCO, both from Outsource and APSCO UK, along with a lot of our members, wrote to the government recently, had meetings with the government recently, because we were told that we were needing to revert back to face-to-face checks. Now, at the time, it was going to be in June. That date did get moved out till later this month, but we were all alarmed that actually was going to happen, because we felt that the current process of doing this in the way of the world these days, which is through Zoom and Teams and digitally, was better. Adam, what are your thoughts regarding that decision by the Home Office is still going to revert back to face, but just a bit later this month?
Yeah, and it's an interesting move they've taken, because as many employers will be aware, there's a right to work check for EU nationals online to check status to work within the UK, but strangely there is nothing that you can do for UK and Irish nationals to check right to work sort of digitally online. Home Office has just released a consultation on whether or not they should introduce a similar portal for UK and Irish nationals, and it seems to be almost a foregone conclusion that the answer to that consultation should be, of course they should. But in the meantime, we have to do the best we can to comply with these requirements. So, if we look at Volt and take a look at ourselves, we're quite fortunate in the sense that we're a large business with a global footprint. However, realistically, the UK isn't made up of businesses like that. If you look at a small organisation who recruits only in the UK, perhaps they're based in Bristol, but their candidate is in Aberdeen. How is that organisation ever going to meet that person? And if we look at the way that working methods and practices have evolved, particularly over the last 5 years in particular, this face-to-face screening, it's fine for the old style of employment where everyone works on site on a permanent basis. But with the development of the entire gig economy, surely that's unserviceable now in its current state. And these rules are almost destined to fail from the outset, you feel. So we certainly need an online system that everyone can access remotely. And really the best thing the government could probably do at this point is to bring an online check-in service in as soon as possible for UK and Irish nationals, the same as they do for EU nationals.
Yeah, I think though, obviously that you mentioned also earlier the forced and slave labour, and because that often is a backdrop for a lot of these decisions, that and of course money to put new systems and things in place. We won't forget that. But from that perspective, Dawn, if we took, that is the backdrop, forced and slave labour, how can customers protect themselves?
It's tough. And I mean, right to work is a small part of that, of course, because forced and slave labour are, very often migrant workers who don't have full right to work. I think key is auditing your supply chains and not thinking just because in your eyes what you're buying is a professional service, that doesn't mean someone down the chain isn't necessarily child labour, forced labour, slave labour. And obviously this is much more compelling for our global clients because they might be buying things in countries which have completely different laws from us, where it's perfectly legal to employ a 12-year-old. It's perfectly legal to have someone work 18 hours a day. And as a business, you need to both understand what the local law requirements are in the country you're doing business rather, but also, are you comfortable with that? If that hit the news that you had a 12-year-old working 18 hours a day, actually, do you want that as the image of your company? So I think thinking in advance, what are the potential PR problems that might cause, making sure you get those in the contract. But also if you're buying something like IT services, we tend to think of that as a classic outsourcing situation. IT's been outsourced for years. But if you've got something like a low-level help desk support, and actually you as a client, all you do is you pick up the phone or you drop an email to an inbox and someone solves that for you. If you don't know who is solving that, you actually don't know enough about your supply chain. You don't know whether or not that person is properly employed, properly engaged in the country they're in. Do they have the rights and freedoms that either we would expect or which are mandatory in the country they're in? So it's making sure that you know who is in your supply chain, because it's not just the party you contract with, it's all the other parties that are down the chain from them. Which countries are they in? What laws apply? If you haven't mandated those things in your contracts or in supplier process documents, and then if you're not auditing it later, then you could have a press disaster coming down the line. I mean, fortunately, it's less of an issue in the UK now. The breaches tend to be more around things like breach of national minimum wage, things like that, which are quite often inadvertent because that's a really complicated piece of legislation that's quite easy to get wrong. But I think, don't be ignorant of the fact it can happen in the UK, but it certainly is a much bigger issue if you're buying your services on a global basis.
And just staying with that global theme, I just want to touch on one other thing, which is you mentioned about the different legal requirements of each country, which are vast. That's we could do a whole 3-hour webinar just on that one topic.
Yeah.
But one thing I did want to just say, it's not just the legal requirements, is it? It's the cultural cultural issues, for want of a better word, that organisations need to be mindful of. What sort of things do we mean by that, Dawn?
Well, as a starting point, whatever it is you want to buy, is that commonly purchased in the jurisdiction that you're going to? So thinking first of all about MSP and RPO, if you're doing business in the United States and the UK, incredibly mature markets. Any large client knows what they are. You don't need to start with that conversation. But if you step not too far away, if you just go across the channel to France, actually they're really not as common. And there's good reasons for that, because it's legally very difficult to do it. But actually there's a cultural issue as well, that because permanent employment is the usual setup there is a certain amount of unwillingness to engage with contracting, being a little bit suspicious of it. Contracting is also very highly regulated there. And so there's sort of the battle for hearts and minds. First of all, you've got to persuade people that what you're doing, although new and scary, can actually bring them benefits. And sometimes an area which is often perceived as a challenge area, so unions, which are often perceived as challenges by clients, actually can be a great friend in these situations, because the one thing that MSPs and RPOs do really well is provide brilliant visibility and brilliant compliance. So you can have a one-stop shop to see what the pay rate is, what the charge rate is. And so from a union perspective, who wants to be sure that everybody of the same type of worker gets the same wages and works the same hours, actually it's really easy to get union buy-in with that kind of thing. So I think sometimes you need to reconsider who your natural friends and natural enemies are in that process. And sometimes we've certainly found that actually reaching out to unions has been the way that we have got across client buy-in, because the union said, this is brilliant, we've got this visibility that we've never had before. And the clients turned around and said, wow, no one's ever got the union on side before. This is fantastic. How did you manage that? So I think you have to unknow all of your preconceptions effectively, and go in accepting that you are a novice in a new jurisdiction, speak to people locally, get as much information as you can on the ground, but always be prepared that you might have unexpected challenges. A few years ago, we started doing business in Saudi Arabia with a client, and it took 5 attempts to find a law firm that would deal with me as a woman. And I must admit, I kind of thought we were in the 21st century, those days were past, but you know what, they haven't. And you just have to take it on the chin and go, okay, I don't like that, but it's better I know that up front, because otherwise that would have caused me a problem down the line when they refused to take instructions from me. So it's just about constantly allowing yourself to be challenged by the fact that every new jurisdiction will teach you something you didn't know previously.
Yeah, absolutely. Very, very helpful. On that, I want to pick on that topic around visibility. So particularly when we think of MSP, RPO, the VMS, the technology that underpins those programs really is that, forever, particularly on a first generation customer, that's the biggest part of the sell, isn't it? Total visibility, because we know that total visibility ultimately means some form of control, and in risk and compliance, visibility has to be a critical factor. So if I was thinking, from a VMS standpoint, Adam, is it really possible to get one VMS globally, do you think?
And I guess the way I look at this, and I've seen sort of various clients try to do this in the past, is that it comes down in my mind to data protection at the end of the day, and these rules can vary wildly from country to country. I've not spoken to a VMS personally who has a solution for everything, and I'll give an extreme example. But if you consider Russia, or the vast majority of countries that previously represented the USSR, for example, but Russia in particular, where you can't take personal data out of the country, the only way you can make that work is to go via statement of work. And you do have certain firms. One firm I'm aware of has sort of 1,200, 1,300 contractors in Russia. They're all statement of work, because essentially there's no personal data on the assignment coming out of the country. It's a statement of work and a reference number. So the question then also comes down to, can your VMS not just operate on a multi-regional basis, but can it also handle statement of work as well as time material contractors, which automatically bumps a lot of VMSs out at the first hurdle. But yeah, I'd say the concept of data protection, in my mind, would stop a truly global VMS solution.
And then in order to, have that total visibility, how important then is it to audit your service provider? It was something Dawn touched on earlier, actually, but yeah, from that standpoint.
I think anyone that I guess in staffing, right, the reality is there's so many things that can fall down in the process. So if you and your provider are not keeping an eye on these, they likely will. And where does that most commonly happen? Well, one is onboarding. So if you aren't checking or auditing the onboarding process, then even with the best will in the world, mistakes will happen and suppliers may not fulfill their obligations. That may be intentional, or it could be, unintentional, perhaps just through communication, interpretation of what those audit requirements are. So you can never be 100% certain that those people in your organisation are compliant to either company or legislative requirements, unless you're actually doing that audit on a regular basis. So you could end up with, in theory, if someone, without the right to work, on your premises, the fine for that is £20,000. But this probably isn't the main risk, certainly to large global companies. The main risk in that instance will be the reputational risk from having your brand splashed all over the front page of the newspaper. We think about reputational risk, think about Cristiano Ronaldo in the Euro 2020s recently. If you saw that interview where he moved a very famous soft drink and the effect that had on the share price in the preceding hours. So the reputational risk here of getting this wrong, sort of holds, I think, the real cost. And Dawn touched on it earlier, but it's also around how payments are managed. So particularly if you're dealing with quite a complex PAYE tax system, you could have unwittingly have contractors below minimum wage in your organisation paid through what on the face of it looks like a compliant tax structure. Similarly, you could also have non-compliant tax structures. Obvious example of this being, you tell your suppliers, yes, this person is inside our IR35. Sorry for the IR35 reference, but hey, guess what? They're actually being paid outside of IR35. So This robust auditing process for suppliers is what's going to save you from that PR disaster, because some breaches you're only going to find if you go looking for them, and it acts as a good deterrent as well. So you'll quickly shake out those offenders early on who aren't complying, but you need to revisit these audits. It's not a once-off process, and it's not something that you can just repeat. You need to switch them up year on year, because those, if you do have those in your supply chain that are doing this deliberately, they're going to learn pretty quickly how to get around your audit if it always looks the same.
That's brilliant advice, Adam. And I guess, Dawn, I just want to come to you there on that point around the law, as you know, because you live it and breathe it, is constantly changing. So how do you ensure? So one part, which I hear loud and clear from Adam, is change the audit process, have a robust process in the first place, regular, change it up in order that people don't buck the system. But then also, how do you ensure that your service providers are compliant if the law's constantly changing?
So I think start with your contract. So when you enter into a contract with your supplier, make it a requirement that in your quarterly business reviews or whatever your usual process for meeting up and discussing how things are going, one of the standing topics on that agenda is legal updates, what's coming down the road, what things need to be changed. And whether you're HR, procurement professional, follow up on those assiduously. If it looks like you're going to need a change to your contract to enable those changes to be made or to enforce whatever compliance you as a client want, make sure those are done. But obviously that's only one part of the equation, because that is dependent on your provider being honest and also being as well informed as you want them to be. So if you have an internal legal or compliance team, I would be checking up with them to ask them what things are changing within the industry. I would reach out to organisations like APSCO who are experts in this area and can give guidance on how matters are changing. The things that APSCO are lobbying on now are the things which are going to be facing lawyers' desks 18 months, 2 years from now. So that kind of information is invaluable. And obviously benchmarking yourself against competitors. What are your competitors doing? 3 years out from IR35, are they getting ready, or have they got bigger things on their plate? And it's about making sure that you trust your provider, but also you can make your own educated choice, and be that through reaching out to trade bodies, your internal legal team, external legal advisors. You do need to triangulate that information to make sure that what you're receiving is all the information you need.
Throughout this has been so interesting, and you've given us snippets of like what I would call really useful takeaways for customers, and we bounced across different areas. As I said earlier, we can't cover everything, but I think we've sort of given people a sense of the different areas. Are there any things, just to summarize, Dawn, are there any other key takeaways that you would want to promote to the end user client when benchmarking themselves?
So I think, first of all, start from the top. Who are you? Are you a first or a second generation client? How much do you know what you need? Because actually a lot of clients start the process not knowing what they need. And once you've established that, you need to work out what your must-haves are and what your nice-to-haves are. And you really need to challenge yourself on that, because I've never yet met a client who knew that during the first conversation. And the must-haves and the nice-to-haves switched places constantly in those initial discussions. And as a client, if you go into that really knowing your position, you can obviously negotiate a much better deal. And obviously, if you don't know your position, you could end up buying the wrong thing or buying the right thing for the wrong price. So there are a lot of implications of making sure you do the preparation up front. And I appreciate that can be a real challenge when you're discussing this with the board, who want things done now or preferably yesterday. And actually you do need to dedicate a good piece of time to researching what you have and researching what you need, or you will pay the consequences of that down the line. And again, this is another classic benchmarking situation. Understand both what you have internally and what your competitors have. Use that to challenge your own expectations in terms of what you think you need and what you actually need. And then obviously think also, what's your personal experience as a buyer and what's your company's experience as a buyer? That Rome wasn't built in a day. As we've talked about previously, risk is a journey through the lifetime of a relationship, and you will, as a first generation client, you'll probably have a lot more risk, and as a second, third generation client, you would hope to have significantly less risk. but you can't make that step all in one go. We've implemented MSPs over the years where the clients come in and said, well, we want, you know, 20 million pounds worth of insurance. And we said, we're placing administrators who sit at desks, you know, and what do you have at the moment? Oh, well, we don't ask for any insurance at the moment. Okay, well, you need to start in small steps. You're never going to get your supplier base. You're going to have nobody who has that level of insurance and no one who's going to be willing to buy that level of insurance. So absolutely, if you don't have any insurance requirements in your contract at the moment, that's something you should definitely address early on. And you also want to come back to auditing, check that they actually hold the insurance that they're mandated to hold in the contract. But you need to appreciate that it's a journey. And if you try and take too big a step to begin with, all you will do is disenfranchise your supplier base, which will have an impact on your access to talent, your ability to have services delivered to you. It will affect your timelines, it will affect your costings. So there is always a delicate balance to be played between the compliance that you want and the cost that you want and how quickly you want to proceed along each of those pathways. Which kind of comes back to, again, how important is compliance to you? And every client we speak to begin with is very important, very important. We're very focused on compliance. And then we lay out all the options and then we lay out what the cost of those options is. And then we discover they're not as focused on compliance as they said they were. Because actually for all companies, and this isn't a critique, there is a balance to be drawn between what risk you're prepared to accept and what price you're prepared to accept. And that will change over time. You know, if as a company you've had a recent PR disaster, you will be very risk averse. If you've had 20 years of no PR disasters, you're probably going to be quite relaxed. And so especially, and this applies for clients and suppliers, you need to respect on both sides that will change over time. And you may improve your compliance, but also you may step back because there's a period of time where, especially if your client's going through a financially difficult period and all the pressure is on how much money something costs, then actually that might be a period of time where your client is prepared to cede some things because actually the cost is the most important driver at that point in time. And then obviously when you're selecting a provider, make sure you choose someone who matches your business. Obviously, if you're buying services from a big global organization, you get financial security with that. And a lot of procurement professionals feel very strongly about that. They want to know the financial worth of the provider that they're trading with. And I understand all of that. But also, you know, this is a people business. Everybody works with people, everybody buys from people. So they can have the best financial records in the world, but actually if you can't work with those people, if they just have a different business methodology to you, there's just going to be a clash. So make sure you choose a provider who you can find some ideological middle ground with. Otherwise, that's just going to cause problems down the line. You know, as lawyers, we write dispute resolution procedures in contracts and we hope never to use them. But if you get the wrong provider, you're going to be using that process all the time. And that's really a process you want to put in a drawer and never look at again because you just want things to work. And so the crucial point is finding that provider that matches you. You know, and again, you know, use your contacts in the industry, ask competitors what they use. You know, go out to, you know, you don't have to go too far. You can go onto APSCO's website and see who their membership are. And through that, you can kind of find out who the reputable organisations are in the business. So even if you're starting from a relatively low level of knowledge, it's quite easy to go out and become more educated quite quickly, which will allow you to make better decisions as you go. Negotiate the best contract you can. I mean, as a lawyer, I'm bound to say that, aren't I? And that is crucial, don't get me wrong, but the best contract in the world that nobody ever looks at and nobody ever audits isn't going to help you in the long run because nobody wants to get to court. That is the position of absolute last resort. What you want is for things to run smoothly all of the time. You know, and as Adam touched on earlier, some breaches of contract are really obvious. If a contractor is due to turn up on Monday and they don't, your eyes are wide open to the fact that you've got a problem. But if you don't have visibility of how your contractor is being paid and somebody down the line isn't withholding tax and social security, the classic R35 situation that we've seen over the last year, you've got a really big problem coming because you weren't checking. So auditing is absolutely key. So I think for me, those would be the really kind of big ticket takeaway items is that, you know, start from the beginning, make sure you know what you know, be honest about what you don't know, get the best deal you can with people who you think you can work with, but make sure you do audit. You both mandate your supplier to audit things, but also you go in there and spot check things yourself, because if you're not doing that, you've no idea what somebody might be hiding behind closed doors.
Thank you so much, Dawn, Adam. It's been an absolute pleasure. I think we should have an ongoing series, Lunch and Learns with Dawn and Adam, moving forward. Yeah, 15-minute blasts of a topic. I think that would work brilliantly. But for now, thank you so much for joining me today. It has been, a real eye-opener. Thank you so much to both of you.
Thanks, Mel.
Thanks, Mel.